Hello and welcome to Verdictum. I'm Sheetal June and you're watching today's legal news, where we update you with the latest legal developments across the country. Starting with the headlines. Mere failure of wife to take care of elderly parents of husband does not constitute cruelty, Allahabad High Court. Whether a remark is sexually colored or not is a matter of trial. Kerala High Court refuses to quash sexual harassment case against Major Ravi. Centre defends 2019 law on triple talaq in Supreme Court, says practiced legitimized abandonment of Muslim wives. Karnataka High Court grants interim relief to CM Siddaramaiah in MUDA Land Scam Case. Now the news in detail. Allahabad High Court has ruled that mere failure of wife to take care of husband's elderly parents does not necessarily constitute cruelty, as such claims are inherently subjective. The court was considering an appeal from a man seeking divorce on the grounds that his wife had not fulfilled her moral duty to care of his elderly parents while he was away serving in the police force. The husband argued that his wife's failure to provide care amounted to cruelty. A division bench consisting of Justice Soumitra Dayal Singh and Justice Donadi Ramesh said, mere failure to take care of aged parents of a spouse, that too when the spouse had chosen to live away from his matrimonial home, may never amount to cruelty. What exact situation may prevail in each household is not for the court to examine in detail or to lay down any law or principle in that regard. The court observed that the husband did not establish what level of care was necessary or desirable, nor did he present evidence of inhumane or cruel behavior. The Kerala High Court has refused to interfere with the order that took cognizance of the offence of sexual harassment against filmmaker Major Ravi, who allegedly defamed and sexually harassed the chief coordinating editor of AsiaNet News. The court was hearing a criminal miscellaneous case filed by the petitioner against whom the offences punishable under sections 354A, 500 and 501 of the Indian Penal Code and sections 120O of the Kerala Police Act were alleged. The bench of Justice P.V. Kunnikrishnan observed, simply because of a legal embargo regarding some of the offences, the order taking cognizance as far as the remaining offences need not be set aside if there is nothing to interfere with the same. The petitioner Major Ravi is a former army officer and a celebrity. The second respondent is the chief coordinating editor of AsiaNet News. The case was registered based on a complaint filed by the second respondent alleging that the petitioner had defamed and de facto complainant had also committed the offence alleged in the final report in a speech made by him at BTH Hotel, Ernakulam. The centre had informed the Supreme Court that triple talaq legitimized and institutionalized wife abandonment, defending the 2019 law, criminalizing the practice and urging that the petition opposing it be rejected. In an affidavit filed in court in response to petitions challenging the law, the Union of India stated that despite the top court's decision to strike down the practice in 2017, it has not worked as a sufficient deterrent in bringing down the number of divorces by this practice among the community members. The practice of talaq-e-biddat, instantly pronouncement of triple talaq, did not simply result in a private injury but in a public wrong as it militated against the rights of women and the social institutions of marriage itself, the Ministry of Law and Justice said. The government responded to a writ case brought by the Samasta Kerala Jamaatul Ulema, which challenged the legitimacy of the Muslim Women Protection of Rights on Marriage Act 2019. The affidavit stated that there is no basis for the allegation that because weddings are under personal law, they are immune from the application of general criminal legislation. The government further rejected the argument that because the unlawful activity had no legal advantage for the perpetrator, it could not be considered a crime. It also stated that identifying infractions and prescribing suitable sanctions is a key function of the state. The Karnataka High Court has urged the trial court not to take any action against Chief Minister Siddaramaiah after Governor Thakur Chand Gehlot approved the Congress leader's prosecution in the alleged MUDA Land Scam Case. The interim respite for the embattled Chief Minister will remain in effect until August 29th, when the High Court will consider the issue again. Siddaramaiah had moved the High Court against Mr. Gehlot's decision to prosecute him, seeking interim relief on the grounds that the governor's action was illegal and without authority of law, and that allowing his prosecution posed a grave and imminent risk of irreparable harm to his reputation, as well as disrupt governance and potentially result in political destabilization. In its order, the court stated that document provided by the Chief Minister referred to several points of order to prima facie demonstrate that the order granting sanction to prosecute bears non-application of mine by the Governor. The court also underlined the Chief Minister's submission, which stated that the Governor had sanctioned the former's prosecution at breakneck pace after complaint was filed on July 26th. That was all on today's legal news. Thank you and keep watching Verdictum. Subscribe to our channel and download the Verdictum app on iOS and Android devices for latest legal updates.